Well, that destroys the whole concept of separation of powers and checks and balances within our constitutional framework.
To verify a treaty has always been the basis, one of the elements of any agreement between ourselves and the Soviet Union, because many American people buy the notion you can't trust the Russians. So we must now verify what they are capable of doing. Ronald Reagan comes on television, I will support bilateral, verifiable, tough, negotiated treaties. But at that very moment, he is asking the Congress of the United States for research and development, procurement and deployment funds for weapons that go beyond our capacity to verify. The ground-launched, sea-launched cruise missile is such technology. You can put a cruise missile anywhere, on a fishing trawler. It's a small, compact, deadly weapon. It is a nuclear weapon. It has the capacity to destroy life. To go beyond research and development, to procure and to deploy this weapon, what does that mean? Can we indeed believe that the Soviet Union would sit down and negotiate a treaty with us when they can't verify whether we're living up to the treaty? So at the very moment that we are talking about verifiability, we are developing nuclear technology that is undermining our very capacity to even sit down and negotiate a treaty.
The Greenham plaintiffs maintained in their lawsuit that the deployment of cruise missiles violates numerous international treaties signed over the last 100 years.
There are a number of tenets of international law that clearly forbid the use of nuclear weapons. One cluster of them has to do with the laws of war, the sort of standards for making sure we don't blow ourselves up when we get into wars, like you can't use weapons that unnecessarily kill civilians, you can't use weapons that poison the environment, you can't use weapons that indiscriminately hit targets beyond their militarily essential nature, and you can't destroy the culture of the people you're fighting. All of those things are descriptions of what nuclear weapons in fact do.
The United States attorney handling the case, Rudolph Guiliani, declined to be interviewed for this documentary.
It may be a decision that you could disagree with, but it's not one in which you should be able to challenge it as being unlawful.
The U.S. attorney argued that the deployment of cruise missiles does not violate the constitutional rights to life and liberty under the 5th and 9th Amendments.
There has been no deprivation of life, and plaintiff's speculation that there will be is just that, speculation. Moreover, this due process claim begs the question and points out the central weakness in plaintiff's case. The relevant process here is the political one, executive, diplomatic, and military decisions by elected representatives of the United States and Great Britain, among other nations. This process is not reviewable in the courts.
The government defense claimed that the courts are not the proper place for challenging foreign policy and that they shouldn't interfere with the constitutional powers of the executive and legislative branches of government. According to the government, Congressman Weiss and Dellums, as individual congressmen, do not represent Congress when they claim that the deployment of cruise missiles violates the war-making powers of Congress. And while trying to keep the case from reaching the courts, the U.S. government attorneys presented arguments in support of cruise missile deployment. The Reagan administration maintained that the missiles had been sanctioned politically in both the United States and Great Britain, and that their deployment went ahead with the approval of Congress. The government argued that the deployment of crews in Great Britain is not tantamount to a declaration of war, and that the cruise missiles are part of a global defense strategy based on deterrence.
I would argue that the decision taken by the NATO nations in December of 1979 to deploy Pershing II and cruise missiles is a decision which will enhance stability. It will improve the more destabilized situation which existed prior to the deployment of those systems by NATO, in which the Soviets were the only ones to have those weapons. That I find destabilizing, because deterrence is undermined. And I think that's an argument that the Europeans used to great effect within the forum of NATO in the discussions and consultations and analyses that led to the '79 decision for deployments. At the same time that NATO took the decision to deploy cruise missiles and Pershings, it took a decision to seek negotiated reductions in these systems. And we have since 1979 been seeking an arms control agreement with the Soviets on these systems. And our preferred outcome, which we have placed on the table in Geneva, is the complete elimination of cruise missiles, long-range cruise missiles, of Pershings, of Soviet SS-20s. This is our objective in Geneva.
The logical result of the plaintiff's theory would be the illegality of all intercontinental missiles in the U.S., which have the capability of reaching the Soviet Union with nuclear warheads, and all nuclear submarines which are in various parts of the world's oceans, and ultimately of all military weapons and personnel. The plaintiffs are very presumptuous in deciding unilaterally their right to survive under international law. First, plaintiffs are very presumptuous in deciding unilaterally that their asserted right to survive prohibits an action conceived and taken to ensure the survival of Western Europe, the United States, and the entire world.
In dismissing the case against cruise missiles, U.S. District Judge David Edelstein expressed the inability of courts to judge the merits of foreign policy decisions.
Undoubtedly, it can be said that the President and Congress cannot know with an absolute degree of certainty the effects of missile deployment. But it is precisely because the ultimate effects are not altogether knowable that conjecture and prediction about them are best left to the political branches of government.
The district judge rejected that view and said that the case was one that the courts can and should decide, but as it turns out, he couldn't figure out how to do it. And he generalized that to saying that the courts were inherently incapable of actually deciding the case, although they had the power and duty to decide it. And it's that inconsistency that's led to our appeal and the attempt to get the Court of Appeals to send the case back to the district court with instructions to please try to decide it.
You're maintaining that the court is capable of hearing the evidence?
Yeah, it's perfectly capable. They hear much more complicated things all the time. Have you ever seen a big antitrust case? Or, for example, the Westmoreland libel trial that's going on now. They've been going on at great length in our case about how military information is not anything that can be evaluated by a court. And in the same building, downstairs, for weeks and weeks and months, they've had all these people talking about all kinds of very complicated military information and intelligence estimates and troop strength and this and that, so that some jury can try to figure out whether CBS libeled Westmoreland.
Decision of the district court was appealed, and on January 21st, 1985, the Greenham women came again to New York to argue that their case should be heard.
We've just come out of court today where the court heard our appeal against the decision of the district court judge, which was given last July. Now, the district court judge said that he could not decide the issue of cruise missiles because it was too complicated and he couldn't find out the standards for judging our case. In front of the appeal court today, our advocate argued very capably that this is exactly the kind of issue for which the United States has courts, and however complex the issue, the court should not back away from deciding whether the Constitution is being obeyed and whether international law is being broken or not.
What happened this morning was that we presented our arguments to the appellate court about why the district court was wrong in dismissing the case without trying to determine any of the issues that we raised. The government responded, as they had in the district court, by saying that there was really nothing for a court to decide at all, that the issues were exclusively committed to the president, and no matter what the president did, it was all right. We responded that that wasn't what our Constitution is about, and there were additional arguments back and forth about the proper role of international law in the United States legal system. The court listened to the arguments and said they'd render a decision at some point in the future, not yet determined.
On February 8, 1985, the case was dismissed by a panel of 3 appellate judges.
Judge Edelstein held that decisions regarding the deployment of cruise missiles cannot be resolved by courts because of the lack of judicially discoverable and manageable standards. Without suggesting that his analysis is in any way incorrect, we believe it even clearer that the complaint of the non-congressional plaintiffs raises issues which have been committed by the Constitution to coordinate political departments and requests relief which cannot be granted absent an initial policy determination of a kind clearly for non-judicial discretion.
In January this year, the coldest day I've ever experienced, sub-zero temperatures in New York City, and an incredibly hostile panel of 3 judges, and something like 20 minutes or so to actually make our case. Not the case that cruise missiles are illegal under international law or that we are being harmed by them being placed in Greenham Common. We were still only at the level of the technicalities. Could the court hear or not hear the issue?
It will have had a very large, very significant impact on legal thinking about nuclear weapons and on the ability of the peace movement to put together a very coherent case against the missiles and to fight it through over a fairly long rocky terrain we've been crossing for the last 15 months. I think all the information that we've put together is there as a resource for the peace movement in all our countries, in many countries around the world. And the arguments which we've brought into the court in this instance are going to be used many times over in future cases in this country and in other countries. And I think eventually somebody somewhere is going to win one of these cases if we live long enough.
There's too much knowledge now, and each one of us has an individual responsibility to do something. It's only going to be when each person has decided for themselves, right, I'm going to do something because I'm frightened, not because I just read this book that tells me, oh, you know, 10 million warheads. I'm just frightened, and I've got these children, and I look at their faces, and they come when they've broken their skin, they've got a cut, and they say, Mum, would you put a plaster on this cut for me? And you can do it, and they smile, and they're better. And then you read something about Hiroshima, and you read about the kids with their eyes burnt out, and you look at your child, and you think, could that be my child? What would I do if I couldn't kiss it better, if that was what my child's future held? And that's why we're there. And what we've done is we've gone there with that feeling, but we've learnt a lot and we've shared a lot. And now we can go into the courts with expert testimony and a 400-page argument and the accumulated knowledge of many, many people. And we can also argue at that level. And it's that sense of caring and knowledge that makes this so strong.
The broadcast of the preceding independently produced program was made possible by the Pennsylvania Council on the Arts and by the subscribers to TV 12.